The process of determining heirs in Arkansas and the importance of estate planning. My name is Leon Jones Jr. I'm the managing attorney here at Big Rock Legacy Law Group. And while this is not the most exciting topic, it is a critically important question to ask. What happens to your assets after you pass away? And is it too late for your heirs to file a probate? Specifically, the process of filing a petition to determine heirs in Arkansas, or probate, is why taking control of your estate through the proper planning is a far better approach. So let's start when someone dies without a will in Arkansas. If a person passes away without a valid last will and testament, their estate falls into what's called intestate succession. This means the state law decides who gets the deceased person's assets based on predefined legal guidelines. In many cases, family members must go through the legal process called a petition to determine heirs or probate to establish who has the right to inherit the deceased person's property. You only get 5 years from the date of death. And this process typically involves filing a petition in probate court. A family member or an interested party must file a petition with the county probate court where the deceased person lived. Providing evidence of heirship means that the petition must have evidence of family members. That evidence could include birth certificates, marriage records, affidavits, or testimony from people who knew the family. And notification. The court requires that all known heirs and potential claimants be notified, allowing them to contest or assert claims against the estate. And then there's a hearing. After considering all the evidence, the judge will determine the legal heirs and issue an order directing how the estate should be distributed. Now, this process can be time-consuming, can be very expensive, and absolutely emotionally draining, especially when there's family conflict or there's an uncertainty about who should inherit the assets. You do not have to go it alone. Call us here at 501-604-0220 and let us help you get started. Now, while Arkansas law does ensure that assets go to relatives, this process can create some serious problems. Probate cases can take months or even years to resolve, racking up significant legal fees along the way. When no clear instructions exist, heirs fight over who gets what, leading to court battles and fractured relationships. And state intestacy laws distribute property according to rigid formulas. This means that a distant relative you barely even knew could end up inheriting instead of a lifelong friend, a loved one, or a caregiver. But there is good news. All of this hassle and fuss can be avoided with a proper estate plan. By taking the time right now to create a legally sound estate plan, you ensure that your wishes, not the state's default rules, determine how your property is handled. So here's why an estate plan is the better option. You control who gets your assets. With a will or a trust, you get to decide exactly who inherits what, preventing confusion and disputes. You can also avoid the probate process entirely. With a well-structured estate plan, particularly a revocable living trust, you can allow your assets to pass directly to beneficiaries without the need of the probate process. And this does help to reduce family conflicts. A clear estate plan eliminates the guesswork, it reduces the likelihood of fights, and surviving relatives can create relationships with each other and not fracture them. Without proper planning, assets can be tied up in court for who knows how long. An estate plan ensures that your heirs receive their inheritance faster and with fewer legal costs. And you can also minimize some taxes and the expenses. With proper estate planning strategies like trusts and beneficiary designations and gifting, you can help reduce estate taxes and other expenses that might diminish the value of what you leave behind. You can also name guardians for minor children if you have them. Those young children will be allowed to be placed where you designate and not where the courts designate. If you don't have a plan in place, courts will certainly decide, and you don't want your minor children to end up in foster care. And estate planning also helps you plan for any incapacity, not just death. Documents like powers of attorney and living wills can ensure that if you do become incapacitated, someone you trust can make financial and medical decisions on your behalf. Take action now. If you file a petition to determine heirs in Arkansas, it is a frustrating process. But if you create a will, it eliminates those unnecessary delays, it eliminates the legal expenses, it eliminates the emotional stress during this time of grief. You have the power to prevent this process, and you have the power to be proactive, to take steps to create your estate plan. Don't wait. Call us now at 501-604-0220. We can help you draft a will, set up a trust, and make your wishes clear. By doing this, you protect not only your assets, but also your family's well-being and their peace of mind. Give us a call, let's talk soon, and let's get started